Hello, dear friends. Today we'll talk about divorce in Shariat law, divorce in Muslim law, as is being practiced in India. So, the Shariat law comes from its religious books of Islam, and it gets a strength in India through Shariat Act, and then there are several other acts like Muslim Women Act, etc. Then there is a Qazi's Act. These are 1 page, 2 pages act, and you may go through that. So, what is the process of divorce among Muslims, especially after Sharia Banu judgment in India? You know that Sharia Banu judgment abolished triple talaq in India, which is known as talaq-e-biddat in Arabic. And it has validated two forms of talaq, talaq-e-hasan and talaq-e-ahsan. Both are valid forms of talaq. Still today, India still is not following common civil law. So the process of marriage and divorce in India is still following the Shariat rules, and today we'll discuss the process of divorce among Muslims. And why we will discuss this, because we see few people know about these things. Most of people are ignorant. I've seen many advocates, very renowned advocates. They might not be knowing the Muslim law, the Shariat law, as is being practiced and interpreted as of now. So, we'll talk about these issues with respect to both the genders. And first question which I have got is that, can a Muslim woman divorce her husband? Yes, it has been decided as early as in 2014 in a famous judgment by Supreme Court in Juwairiya Abdul Mazid Patni versus Atif Iqbal Mansoori and another, which says that khula is a mode of divorce which proceeds from the wife. Husband cannot refuse. However, this judgment didn't get much publicity, and another judgment which got huge publicity, and it was discussed and in fact was also accepted by Muslim Personal Law Board, in the sense that they debated it, discussed it, and now they accept it as a matter of practice. The judgment has been named XX versus XX, decided on 9th April 2021. The name has been anonymized due to the privacy reasons, and the judge is Honorable Justice A. Muhammad Mushtaq. And the judgment reads the same thing which Supreme Court decided, that woman has absolute right to invoke or ask khula unilaterally. Okay. Now, that is for women. What is the process for men in India to divorce their Muslim wives? Is it that they will send notices of talaq-e-ahsan, which takes 90 days, or they will send notices of talaq-e-hasan, which takes 1 month, and the marriage would be over and the talaq would be valid? No, it's not like that. Any divorce must be for just and reasonable cause. So the question arises that what are the just and reasonable cause which are accepted by courts? Of course, any just and reasonable cause has to come from the natural flow of law and justice. So all the reasons which are accepted as valid under HMA, Hindu Marriage Act, or those which have been decided in several judgments of honorable courts, the same would be acceptable for Muslim divorces also. Again, only a just cause is not enough. After the just cause, one has to go through a process of mediation or arbitration. At the family level or at the society level, or at the family court level, or at the lok adalat level. And of course, if need arises, you need to have evidences for these attempts of arbitration or mediation. So the process, I would explain that you need to have a just cause. Then you need to show your goodwill by approaching the other party. Be for husband is the wife, for wife it's the husband, and you talk it out. And if you don't find any amicable settlement or amicable decision, whether you are living together or whether you are parting, then one party sends the notice of talaq to the other party, and for male they have to send the talaq for talaq hasan or talaq ahsan. Only these two modes are acceptable. Any other mode is not acceptable after Sharia Bano judgment. If so, some Maulana or some so-called Qazi may mislead you by saying that they will send talaq notice under talaq-e-bain or blah blah, that won't be accepted and the male would be in big trouble. Now, the notices are sent. After the notices are received, the talaq process is over. However, if someone is a government employee or someone whose wife's name is in passport and they want to change the name, they have to go through a process of declaration of their divorce, declaration of their marriage status in family court. So they have to approach the family court, where family courts might not be existing. You have to approach the magistrate. So you approach the family court under which law? Under Shariat Act, read with Family Court Act Section 7(1)BB, which deals with declaration of marriage status. And in magistrate court, you might as well approach under a Specific Relief Act. So this is the process, and then you could go for declaration in the family court for unilateral divorce as well as for mutual divorce. If it is mutual divorce, it is much easier. Both parties appear in court and they recognize each other, identify each other, and they give their statements, and the court gives order or judgment that the divorce among them is valid and the same is declared. So as simple as that. And then that becomes a proper court decree. If it is unilateral, then of course you need to lead your evidence. You have to give your affidavit. Court will go through the reasons of divorce, your attempts of mediation, etc. Court of course would be giving notice to the other party to appear. Court will hear both the parties, ad alteram partem. So this is the process of divorce, and let me give you some judgments regarding that. The first judgment I must say, which says that a Muslim male cannot get a divorce decree from court. They have to do it by themselves, is very clear judgment from Jharkhand High Court in the matter of Muhammad Yusuf versus Nasreen Begum, decided on 18 June 2018. So you can find the judgments very easily. And this judgment has been relied upon time and again. And of course, this is basically the crux of Shariat law, which has been documented very well in Mullah Din Shah Faridonji Mullah famous book, Principles of Mohammedan Law. So let me give you some judgments, important judgments related to Shariat law and divorces. Some people try to bypass the process of divorce by simply discarding their wives and going for second marriage. So that is regarded as enormous cruelty to the first wife, and there is a clear-cut judgment from Karnataka High Court titled Yusuf Patel versus Ram Janvi. Then some judgments about declaration. The first judgment I remember is from Karnataka High Court in matter of Zahir versus Gausia, decided on 22nd September 2020. And another judgment about a declaration in a unilateral divorce is Sayyid Ziauddin versus Hasina Banu, decided on 9th February 2022. Now, one query you might be asking, that if you divorce someone, if you divorce your wife, will your divorced wife be able to claim alimony after the divorce? Yeah, the matter is no more res integra. It has been decided several times, and it has been well settled in Supreme Court judgment in Shabana Banu versus Imran Khan, decided in 2009, that a Muslim woman can claim regular maintenance even after Sharia talaq. That's another issue, that whether you can deny her maintenance by showing that she has approached the court with dirty hands. So that is a matter of trial. So this was all for today, and the day is getting dark and I'm not much visible, guys. So if you have any query regarding this, please feel free to ask me, and see you again. Take care. Bye-bye.